Good afternoon. I'm Chris Schroeder. I teach here at the law school at Duke, and nameless. But we're delighted to have her here today, too, and delighted to be the site for this year's CALI convention. I'm going to spend a few minutes, largely without, I think entirely without actually PowerPoint presentations. I do have a couple of things to show you, but I'll wait until the end. To give you a sense of what the basic legal infrastructure is in which civil rights and civil liberties discussions and debates are going on now post-September 11th. And I'll talk for about 15 minutes, and then I'll turn it over to Anne. She'll talk for about the same amount of time, and that way we'll leave ample amount of time for your questions, which I found is a good way to do these kind of talks. Since there's so much going on, it's impossible to anticipate in advance really what people are interested in. Two basic questions I think you could ask about civil rights and civil liberties generally, and then become more specific in the context of higher education, is exactly what are they and how much have they changed since September 11th, 2001. And by civil rights and civil liberties, I will simply mean, for purposes of this discussion, and very roughly, what's the dividing line between us and the cops? When is it that we get to do things, acquire information, talk to people, without worrying about whether there's some government agent who might be capable of surveilling that information, capturing it in some way, and potentially using it against us down the road? I think that lots of people, when thinking about their general question, operate with what I call a basic probable cause model, in which the notion is that, sure, the police have definite duties and responsibilities once there's probable cause to believe that a crime has been committed or about to be committed, and then subject to Fourth Amendment and Fifth Amendment and Sixth Amendment kinds of protections, we perfectly are perfectly understanding of their right to go out and get information and to use it against us, so long as procedures inside the criminal justice system are complied with. And that kind of model, I think, has in many ways dominated the sort of mindset of the FBI over the years, which is our domestic law enforcement agency, has the primary responsibility at the federal level for ferreting out criminals, and to the extent that they have evidence of a crime that's about to be committed imminently, to do something about preventing it from being committed. That's never been the exclusive model under which the law enforcement officers in this country have operated, nor is it the exclusive model under which our civil rights and civil liberties have been defined. And the opposite model, I think, is the model that we've now become used to talking about somewhat in the context of the Foreign Intelligence Surveillance Act, or FISA, which is a statute that I doubt very many people pre-9/11/2001 knew about, and now a great many more people do. This is the act that set up in 1978 the basic apparatus under which the foreign intelligence agencies conduct foreign intelligence surveillance, or colloquially spying on people. And the modus operandi of an agent under the Foreign Intelligence Surveillance Act has never been a probable cause model. It's been a model of more or less assuming that people who are the agents of a foreign power, which is the definition of the scope of who can be surveilled under that statute, may well be up to something suspicious, or at least that we have a right to intercept communications, study what they're doing, spy on them, in order to make sure they're not doing that. The CIA does this overseas all the time. The Foreign Intelligence Surveillance Act establishes the legal apparatus under which law enforcement people can do it inside the jurisdiction of the United States. It's never required probable cause to believe that a crime has been committed to surveil the agent of a foreign power unless that person is a United States citizen, in which case you have to have some evidence that that person not only is an agent of a foreign power but is committing or preparing to commit some illegal action. Now, what happened in 9/11, I think, could be described as a shift from the relative priority that our law enforcement agents are giving to the probable cause that a crime has been committed model over to the spy on you end of the spectrum. We never were pre-9/11 100% committed. We weren't over at the one pole. We were always doing some foreign intelligence surveillance work. It's just that it was never very well visible. In fact, it's a secret court that hands down these orders, so you wouldn't have much reason to know about it unless you had done some work ferreting it out. But there was always a certain amount of activity going on the spying end of the spectrum. And what Congress did with the Patriot Act, the USA Patriot Act, is make some changes in the basic legal infrastructure that makes it easier to spy on people, basically. That makes it easier to ferret out information about people without believing there's probable cause that a crime has been committed, but in the interests of preventing future terrorist acts. I mean, the very name of the Patriot Act, the I and the O in Patriot Act, stand for intercept and obstruct terrorism. That's in some respects, the major overarching purpose of that statute is to give law enforcement agents the equipment that will enable them to intercept and obstruct, not to prove who did it, but to go out and gather the intelligence, do the spying that's necessary to try to prevent it from happening. And in that kind of model, law enforcement activity begins to become a lot more intrusive, begins to ask a lot more questions of activities that seem to us to be, A, innocuous and the kinds of things that we ought to be entitled to do without worrying about government surveillance or supervision. But now, under the provisions of the Patriot Act and other steps that have been taken, the Patriot Act is kind of a catch-all expression for all the changes that have been made since September 11th. There are lots of things the Attorney General has done by his own order, the President has done by executive order, outside of the confines of the USA Patriot Act. But as I say, because we always operated in a world in which there was some of this spying activity going on under the foreign intelligence power, a lot of the description of the kinds of things that you've seen in the papers and that we've talked about in various settings that bother people about the current environment aren't in fact the result of changes in the law after 9/11, but they're the result of more vigorous employment of legal authorities that have always been there. Some examples. There's always been a lower burden of proof when you go to the secret court, this Foreign Intelligence Surveillance Court, to get an order authorizing either a wiretap or the mandatory acquisition of third-party business records or ferreting out or putting a trap and trace on your phone. It's always been a lower standard. As I say, if you're not a U.S. citizen, the standard under that act since 1978 has been the Attorney General or some other high-level official has to have probable cause to believe that you're the agent of a foreign power, which doesn't have to be a country. Although obviously, when the act was written in 78, the big worry was the Soviet Union and communism. Court decisions have expressly said that Al-Qaeda is a foreign power, and the way the act is written, it's apparent that any international organization would qualify. So that's a fairly broad, sweeping power. It applies as I say, to people who aren't U.S. citizens. The FISA Act defines for its purposes U.S. citizens to be U.S. citizens in the way we normally think about it, plus permanent resident aliens. But unless you're in those two categories, you're subject to surveillance under the Foreign Intelligence Surveillance Act, and have been since 1978, on the basis simply of that fact alone. And that, I think, as nicely as anything, sort of captures the notion of that wing of the scale that allows the government to say, we don't really have to have any specific reason to want to acquire information about you. We sort of, there's a presumption that you might be doing something. You might be one of the bad guys, so we get to look at you. It's a very different model than the probable cause model. And all of that existed prior to the USA PATRIOT Act. It was always done before a secret court. The Justice Department makes some annual reports to Congress about activity under the FISA, but it's always been very rudimentary. It's never been detailed. All the orders, of course, are ex parte. It's just a Justice Department lawyer arguing before the judge that this is justified. Third parties who are served with subpoenas under FISA have always been under a gag order. So the concern about libraries having to turn over records of books and then not being able to tell the client that the government's asked for them, and it's always been a problem under FISA. And you've always been able to be detained indefinitely as a material witness, which is something the Justice Department is employing to a greater extent now. But we're becoming to realize that this is the state of the legal infrastructure more after 9/11. And in part, that's because of the changes that have been made by virtue of the Patriot Act. What the Patriot Act did was make it much easier, lower the transaction costs of the Justice Department to use the foreign intelligence side of the street, and expanded the situations under which you could use it. So, for instance, my library example, it was clear libraries weren't covered under the FISA prior to the Patriot Act. Now they're covered by virtue, we think, of an omnibus provision that allows the government to get a foreign intelligence subpoena or court order for anybody's business records or any tangible thing. And that looks like it covers library records and lots of other stuff. Some of what the Patriot Act did, the Justice Department, quite frankly, has been trying to get the Congress to do for years. And the biggest chunk of that is stuff I'm not going to talk about, which is a huge section having to do with money laundering and the ability to get at overseas records and require banks to do monitoring and to disclose and so on. Justice Department's been trying to get that money laundering piece enacted for years, and they have it now. Another set of features of the Patriot Act that the Justice Department have been after for a long time are the provisions that they'll talk about in terms of bringing existing legal rules up to date in terms of technology. What they mean primarily about that is extending it to the internet and to computers. So now, for instance, emails are treated like telephone calls. You can do it, the equivalent of a pen register trap and trace on an email the same way they used to be able to historically on telephone calls. Trap and trace is in the telephone business, it simply allows you to get the phone numbers of the outgoing calls and the incoming calls. The equivalent in the email business is more disputed because there's some doubt about whether you can just get the directional information or whether you're not also capturing some content. And there are other provisions in the Patriot Act that simply try to, in the government's view, allow the government to do the same thing that's been able to do with telephone calls, whether that be trap and trace or wiretap, with the electronic communication. And so, just 1 second playing apologist here for the Congress, and I will disclose I worked as the chief counsel for the Judiciary Committee some years ago. And I also worked for the Justice Department, so I'll disclose that too. There was a lot of talk about how this was a hastily constructed act. Lots of pieces of it, in fact, had been lying around, trying to get passed. And they had been debated, and they had been vetted, and they had been kicked around, and they weren't able to make it, even after Oklahoma City, when the Clinton administration introduced a set of provisions that bear a lot of resemblance to big chunks of the Patriot Act. Eventually, eventually a lot of them got stripped out of the anti-terrorist bill that passed. The bill that passed in '96 was essentially a bill that gutted the habeas corpus law and didn't do much for increasing powers of law enforcement. That was because of a very interesting coalition of conservative civil liberties groups and liberal civil liberties groups. The NRA and the Eagle Forum were as opposed to the provisions as the ACLU was, and the combination of those two was sufficient to thwart the passage then. But people on Capitol Hill knew what these provisions were. They weren't by and large surprises. What happened after 9/11 is there was a sea shift in where members of Congress thought the right place on this spectrum was to be, and they moved it way over to much closer to the pole that says it's going to be okay in a lot more circumstances than it used to be to spy on people. I'm going to stop and turn it over to Ann. I do want to reiterate one thing in closing, that the biggest things that have changed since 9/11 been implicit in the distinctions I've been making between being a U.S. citizen and not being a U.S. citizen. The biggest changes that you will notice are if you're not a U.S. citizen, if you're an immigrant, if you're one of the people who have been, one of the 1,000 people who have been detained for over a year by the Justice Department. The FISA standards are lower with respect to you. The powers of the INS to deport you, of course, are lower with respect to you. They're non-existent with respect to us. And the difficulties now in getting into the country for lots of different purposes have been heightened and made more arduous. So because of the limitations on a number of the legal authorizations for surveillance that make it harder to surveil U.S. citizens, most of the impact of the bill is on a day-to-day basis is being felt by people who are not U.S. citizens. So Ann, with that, I'll turn it over to you.
As Chris said, I'm Ann Klinefelter. I'm the Associate Director of the Law Library at that school down the road, and a clinical assistant professor of law as well. And while I do a fair amount of teaching, I really don't ever use PowerPoint, but since I'm coming to the computer-assisted legal instruction conference, I felt a great need to do this. And I just learned in the previous presentation that because I use the design wizard, this is going to suck. So I apologize ahead of time for that, and appreciate your tolerance. There is also another program going on right now that's about privacy with networks, and so this is going to focus a little more on libraries and IT professionals, but I think some of it will overlap a good bit. We're sort of, I agree that we're talking about the Patriot Act, but also all these other things that are sort of going on in a cultural change, sort of climate change with law enforcement. And the Patriot Act, you may already know, amended 15 different laws, and it was 342 pages long and was passed just 6 weeks after 9/11 in the middle of the anthrax scare. So there was some sense that it wasn't carefully read by everyone. There's not the same amount of legislative history that you hope to find for a lot of big pieces of important legislation. But I think that it's true that it must have been a good bit of it lying around waiting on people's computers, so that doesn't mean it wasn't thought out by some quite a bit. There's state laws for libraries. We're very concerned because there are a lot of, 48 states have laws that protect the confidentiality of records that deal with patron activities. Hawaii and Kentucky have attorney general opinions that they rely on, and you can find links to all of these through the ALA.org, the American Library Association website. Of course, those laws can be preempted by federal law, And in many of the state laws themselves, they acknowledge that there are other legal requirements that would make these sort of protections not relevant. For example, oops, backspace. See how sophisticated I am with PowerPoint? In North Carolina, our law, there are two provisions to it. 125-19 talks about the confidentiality of library user records and says, in terms of disclosure, a library shall not disclose any library record that identifies a person as having requested or obtained specific materials, information, or services, or as otherwise having used the library, except as provided in, we'll see in a minute, subsection B. So you see it's protecting quite a bit, but it does focus on records. So, and this is subsection B. The exceptions are, thank goodness, when necessary for the reasonable operation of the library. Upon written consent of the user, probably not going to happen much with terrorists saying sure. Pursuant to subpoena, court order, or otherwise required by law, there's the big exception that means that, of course, Patriot Act provisions and other ways would require turning over that information. Also, there are definitions. You may be wondering, what does library mean? It's a pretty broad definition in North Carolina, mostly any kind of place that's open to the public. And more importantly, we want to know what a library record means. It does broaden it so that electronic materials can be included, but it says it does not include non-identifying material that may be retained for the purpose of studying or evaluating circulation of library records in general. So you can participate in some kind of surveys or something that tells you about the analysis of your collection. Beyond the law, beyond these state laws about privacy, librarians share a sense of that it's part of our professional ethics to protect patron privacy. And the American Association of Law Libraries, in their ethical principles, says, we uphold a duty to our clientele to develop service policies that respect confidentiality and privacy. So it's something removed from an actual policy, but it does say that we should do something like that. If you look at the American Library Association Code of Ethics, it goes a little farther and says we protect each library user's right to privacy and confidentiality with respect to information sought or received and resources consulted, borrowed, acquired, or transmitted. So that's a pretty proactive thing to say we protect. That makes you think that, yes, we have the local newspaper on speed dial, we have our bags packed, and we're ready to go to jail as soon as they come to jail. And there are librarians, I know, who feel that way about it. The challenges that came from the Patriot Act, what's gotten the most press is the Section 215, and that is the part that amended the law, as Professor Schroeder was speaking about, that already existed. It just didn't include, the definition of businesses was much more narrow, so libraries weren't covered before. This is the director of the FBI or a designee of a certain high level may make an application to the FISA Court, the secret court that he was discussing, for an order requiring the production of tangible things, which used to be business records pre-Patriot Act, broadened now, for an investigation to protect against international terrorism or clandestine intelligence activities, provided that such investigation of a U.S. person is not conducted solely on the basis of activities protected by the First Amendment, which sounds like it might help us, but it pretty much means that there has to be something else already ongoing before they come and look for reading habits. It also says, and this is the part that we get so nervous about and that gets so much press, is that there is this non-disclosure clause. And it's sort of inelegant. No person shall disclose to any other person other than those persons necessary to produce the tangible things under this section that the Federal Bureau of Investigation has sought or obtained tangible things under this section. Okay. Well, one library actually from Alabama I saw was really, they were disclosing that they had been visited by some law enforcement agency and asked for patron records. So they were reading this to say that as long as they didn't mention the FBI, they're okay. So we'll see how that goes. But what's interesting is I really do know, and I've already said this, so I'm sure I'm being tracked, but I do know people who are ready to go to jail on this point, and so I was nervous and trying to find out, well, what's the penalty? And you know, there is no penalty in this portion of the law. It's not explicit. So I thought, well, it's a court, so I guess there's contempt of court, or maybe, you know, I don't know enough about obstruction of justice to know whether that would apply. There's possibilities, but there is a leaked copy of, you've probably heard Patriot Act 2, or referred to affectionately as Son of Patriot Act. It's really called the Domestic Security Enhancement Act, leaked from the Justice Department, and there are penalties in there explaining that there aren't any now, so we need some. So that leaves us, yes?
Has that been interpreted to exclude communication with counsel? In other words, a librarian called the university lawyer with he or she
I am going to get into some more of those, exactly what steps to follow, but it has been, the consensus is that counsel is included. That's permitted. Okay, good question. So in terms of what the Patriot Act 2 does outline is up to 1 year in prison for this disclosure, or up to 5 years if you had some intent to commit a terrorist act or support terrorism, that sort of thing. So I just throw that out. All right. The Patriot Act and libraries, the secret FISA Court orders for tangible, these are the kinds of things that we've been concerned about. We hear the most about these orders, and we're concerned that they're going to come and try to get our circulation or reserve records, sign-up sheets if you have them for use of rare books or for, say, computer terminals, any notes that reference librarians might keep about who asked for what, that sort of thing. As Professor Schroeder mentioned, the pen register and trap and trace devices, those now expanded to include email in addition to telephone. And the roving wiretaps are kind of disturbing because that means that, and you can understand why this happened, no longer are people tied to one particular device, or is it easy to just track a particular person? That's what we used to think about, the specificity of a search. If you're going to wiretap somebody, you have to specify exactly what thing or person you're tracking. But now it can be anything that some person or group might touch, so that the public computers in the library could be monitored because someone may have been there or may be suspected of coming there, and that means everyone who uses that, all of that information is collected. So that's a little bit what libraries are concerned about. Also, I said local and remote. There's a lot of tracking that could happen. Libraries may not know. It may come at the ISP level. It may be something farther removed, and we may not actually know that this tracking is going on. And it can involve the placing of software there. We actually saw a carnivore. I wish I had your slide. A slide about software that can monitor what's going on there. Other challenges, aside from just these sections in the Patriot Act that we hear about, the FBI has said that they'd actually prefer to use something called the national security letters, administrative subpoenas, which would allow them to come get electronic information more easily than, say, tangible things. And so those are things that would come, as I understand them, they're administrative subpoenas, which means pretty much the FBI asks the FBI if the FBI can get this. And there can be non-disclosure requirements with those as well. And also grand jury subpoenas are often used in this regard, and those also have non-disclosure requirements. So it's not just this new section of the USA PATRIOT Act that can require libraries, for example, to turn over information or records and not disclose information about it. Okay, so what are libraries doing? I'm getting closer to your question now. First of all, updating and posting privacy policies. It's likely that libraries, due to professional ethics and these state laws, always had privacy policies, but they may not have been prominently posted, and so this is inspiring renewed revision of language and also some training of staff. Libraries have been concerned that the law enforcement agent will show up at 11 p.m. when the student assistant is at the reference desk and be very persuasive about getting material, and so there's some sense about preparing them, and I'll talk a little more about how you would do that. Also, libraries would be consulting with university council or their directors of public safety to be prepared and have a plan that involves them as well. Conducting privacy audits. Privacy audits would be a way of finding out how long do you keep information in your institution and in what way, and trying to perhaps be more conscious of ways to get rid of materials rather than keeping them. If it's not necessary to keep them, you can get rid of them, and that way they can't be obtained. Also, not collecting unnecessary information. If you don't really need people to sign up to use computer terminals, why collect that information? If the chance that there's going to be some destruction of that property is low, don't collect it. That's what some are doing. Also, you may have seen some information about these signs that are getting posted. Some of them are quite strong, and they direct people. They give the mailing address for John Ashcroft, which I don't quite understand because you can't really change this and wouldn't want to. I mean, a congressman would be more appropriate, I think. But there are also little signs that say things like, organizations who have not stopped by this week. Number 1, Red Cross. Number 2, Boy Scouts. Number 3, United Way. 4, FBI with a line drawn through it. 5, Rotary Club. And then another one, like the FBI has not been here. Watch closely for the removal of this notice. and things like, when you've got that empty space where the computer used to be, a notice that says, if the FBI were to remove this computer, we would not be able to tell you that. So those are some of the strategies that libraries are considering and implementing. Now, when you have guidelines for staff, first you want to let them know that they would need to keep patron records confidential unless an official document accompanies a request. And it's not just those state laws and library ethics. There are also FERPA, which protects educational records, student records, is also in play here. And there may be others as well. And so what has been recommended, and we're just implementing at UNC, is that if you have photocopies of an actual policy that incorporates your state law that are there for the staff to hand to people who might just come and ask for information, then that makes them feel like they're giving something and they have something authoritative to provide in response. If the document says warrant, you must step aside because those are immediately executable. But of course, the thing to do is to call. There's a chain of command idea that those people in the chain of command we're going to assume are necessary for complying with the request. And also counsel. And counsel would probably include a head of public safety. I know that at different institutions, different universities, it depends on who's on that 24-hour call. We've been told, I was told some time ago that at UNC, our head of public safety expected that the library would not be the first place visited, that they would come immediately to the director of public safety or to university council with any kind of request, that we would not be the front line. And that was something that they felt they had a relationship with law enforcement that was strong and it would allow that to happen. So, our fears may be somewhat exaggerated, maybe not, depends on the institution and those relationships. Legal documents that are not warrants, like subpoenas, must be reviewed by university council before compliance. So you would tell a staff member to immediately contact their supervisor for assistance in doing this. And there's language that's recommended, like, I'm not the person who can help you, let me get that person, but always try to be helpful and cooperative. And because there's so many different ways that non-disclosure can arrive at your doorstep, you'd want to treat every request as if it might include non-disclosure. At least tell your staff. Now, this runs contrary to our sense that information wants to be free in so many different ways, but that's probably the safest thing to do, and as soon as possible, library administrators should let people know whether that is or is not the case. It should be in the document that you get. It would have non-disclosure in there, but we want to always train staff to read through and analyze all of those sorts of things. With subpoenas, anything other than a warrant in particular, your counsel can help decide whether this is the scope of it is legitimate and help you comply without going outside of the boundaries of what has actually been delineated in the subpoena. So what is the outlook like? Well, there are sunset provisions for many parts of the USA PATRIOT Act, including these ones like Section 215 that we hear the most about. They are supposed to slide behind the horizon at the end of 2005. And there are these companion bills that have been introduced. You may have heard about the Freedom to Read Protection Act, H.R. 1157, which now has 118 co-sponsors, introduced by Bernie Saunders of Vermont, and that would exempt libraries and booksellers from the Section 215 of the USA PATRIOT Act that expanded the definition of businesses from whom FISA Court orders could be used to obtain tangible things now. And Senate Bill 1158 has recently, third week in May, been introduced, has no co-sponsors at this point, and it is very similar, Library and Bookseller Protection Act. In addition, there is a growing awareness and there's a growing opposition to, in general, this sense of the USA PATRIOT Act, some of the sense that civil liberties are being threatened for not just those, well, for those visiting us, but also U.S. citizens, that there's a blurring and sharing of law enforcement information so that there's a sense that U.S. citizens may have information collected about them under a lower standard that's really meant to be applied to foreign intelligence, but the information gets shared, and the Fourth Amendment violations may occur in that blurring. You'll see a lot more news articles about this now, and there are a lot of news articles about libraries and cartoons about libraries and what in the world, you know, are they doing looking over little old Jane's shoulder while she's reading something innocuous, you know. But it is true that terrorists were found. Delray Beach Library was one of the ones that we've heard the most about, and this may have been right after, it may have been pre-Patriot Act passing, but a librarian there did see people who were rude to her. That's a bad sign. Not nice to the librarian, things won't go well. They were using the internet computers, and you know, they were bearded men. So you're in trouble now.
I've been watched for minutes.
Oh, there you go. And she saw these people on the news that night and did call and say, these people were in my library. And so, you know, it's a tough call to make, and I think the computers were removed. But those are so there is a sense that, you know, there are ways to look at this, that libraries can be a place where terrorists have communicated with each other over the internet, and so that's one of the reasons that is given for looking at library records. Okay, news articles, congressional oversight, where Congress is getting a little more active about trying to get information. They've been following up. They've requested. Some of it was not forthcoming. They've stepped up some of this. There have been, well, I think it may have been EPIC and the ACLU. I'm not sure if I recall, but there were FOIA, Freedom of Information Act requests and suits to follow that to try to get information about how often this is implemented. One of the questions was how often under Section 215 have libraries been visited. We did find out not too many weeks ago there was a description by a representative of the Justice Department that libraries had been visited about 50 times. They didn't say for sure whether it was in regard to Section 215 tracking terrorists, but by the FBI, and this was since the Patriot Act, but mostly at the request of librarians. So that's what they've said. And there's a strange movement, I think, municipalities and states passing resolutions opposing the USA PATRIOT Act. This is tracked on the ACLU website, so you can find out more. Hawaii, Alaska, and Vermont are the states who have passed resolutions opposing the USA PATRIOT Act. Tucson, Baltimore, Philadelphia, Greensboro, North Carolina, and Carrboro, of course, North Carolina, have voted against it. And Seattle and Broward County, Florida, which is Fort Lauderdale. So some big places have, a lot of college towns have. And what is interesting is there is this union of the left and the right, like they've met full circle on this. And in particular, one of the things that has been generated was a letter that was opposing Patriot Act 2. After it was leaked, it's posted on the web. And so you have like the Gun Owners of America right next to the ACLU signing these kinds of opposition letters. Okay. Resources for law librarians, in particular, of course, anyone, if you want to find the text, you know, GPO Access is a great website for legislation. Also, you can find it at thomas.loc.gov. American Association of Law Libraries website, allnet.org, has some information about law librarians and what letters we've written in opposite. Well, in particular, you'll find a letter supporting H.R. 1157, the Freedom to Read Protection Act. ALA.org is the goldmine of information. It provides guidelines for staff, suggested guidelines, a lot of analysis, a lot of links, inspirational quotations, and also the Association of Research Libraries. For those of you who are in institutions that belong to this organization, they have a spec survey. They do all these surveys of member institutions, and it may be your main libraries who are most involved in this, but one of those that's ongoing right now is all about privacy audit. And so once you complete the spec survey, you know you've done your privacy audit, so that could be useful to you. And LLRX.com is a site that is used by law librarians a good bit, and Mary Minow is a very good resource. She's a lawyer and a librarian who's written a good bit about intellectual property in libraries, and also is really on top of this topic and has done a number of charts and guides. EPIC is electronic privacy organization, and they have a good bit of information tracking USA PATRIOT Act and this kind of thing. And as I mentioned before, ACLU.org is tracking municipalities and a number of others too, and they have offered to represent any institution that is served with a FISA Court order for tangible things. So that would apply to libraries too, although probably those of you at academic law libraries are going to use university counsel. But that's something to keep in mind. Okay. So I'll just close with this, because there has to be a reason for using the wizard. It's the lock thing here. So that's the theme is, if you think these things are kept away, think again, because they may be available. So the best strategy is to get rid of the information as fast as you can. I know most of us have electronic or integrated library systems. As soon as a book is returned on time, you completely disengage the link between the patron and that material. So a lot of that is already part of our systems. And then you said you had some other things you might want to add, and I think we're going to have some questions.
I was going to provide a couple more websites.
Oh, good.
I don't think I'll take the time to load the PowerPoint just to show them. But for universities, aaup.org is a good site with helpful links. And Cornell's IT site is a very good site. Someone up there is taking a real interest in the Patriot Act. So www.cit.cornell.edu/OIT will get you their main page, and they've got a link to their Patriot information, which is very good. Then my favorite site is www.patriotwatch.org, which again has lots of cross links and collects news articles and anything that's happening around the country on the Patriot Act. And then EPIC and ACLU and the other sites that Ann listed are good too. So.
I enjoyed both of those presentations. I talked about the Patriot Act a good deal. and try to raise concerns. And understanding from the librarian side that there's this institutional mindset of confidentiality. And I appreciated the preparatory remarks as well, because I think they were fairly neutral. But one thing that perhaps people don't understand is what a big deal it is to go to the Attorney General and get a FISA warrant, because the Attorney General physically has to be briefed on it, physically has to pick up a pen, sign it. Counsel have got to go to the secret FISA court, which meets about every month, and they've got to brief the case, and obviously the standard is fairly low. But it is probably not just going to be a fishing expedition, because you aren't going to get the Attorney General to sign off on this thing unless he's convinced that it's going to be more than a fishing expedition, because you don't go to the FISA court for small fish. So the chances of you encountering a FISA warrant are relatively small. And to the extent you may have a mindset that this is a real threat to civil liberties, personally I think there are other aspects of the Patriot Act that are of greater concern. And also, material witness statute, and look, immigration law is a nightmare. If you want to get real concerned about civil liberties, that's an area where you could be real concerned. The Patriot Act, and the chances of a library getting a Patriot Act subpoena, relatively low, but again, this is a well-balanced presentation that you might get one.
Now, I mean, I know that the Justice Department mentioned 50, but Bernie Sloan at the University of Illinois has done a survey. The numbers are a lot higher.
Yeah. Well, he surveyed that's the University of Illinois Library Research Center, surveyed anonymously public libraries, large public libraries across the country, and I think they had like 10 or 11% said that they had been visited, but it didn't distinguish whether it was 215 or whether it was somebody coming to find out who's been stealing all the laptops. But
I forgot the numbers, but they talked, and there was a leak of information as to how often FISA had been used right before 9/11, and it was 100 odd times. And I would say after 9/11, it's many more times. They are actively using FISA warrants, but again, probably not a lot. Probably a lot less than you think.
well, one of the things that was provided to the Congressional request was information about how many of those requests had been turned down, and it was none.
But
So
again,
that could be because it's gone through an extremely good process that you're describing.
that was a week when I went to the CIA, and they briefed us on this last year at a national security course. It was, we didn't take anything, and this is there because the mindset of the FISA court was not as it is now, where the Supreme Court has straightened them out and said, look, it's probable cause that they're an agent of a foreign power, not probable cause that they're committing a crime. That was the standard before. And so the reason why they only took, I think it's 200 total cases that prior to 9/11, since 1978, that they had taken to the FISA court, and they had turned down none. Every single person that talked about it said, we don't go there unless we have a really good, strong case, because we did not want to have a case turned down at the FISA court. And the judges prior to the recent Supreme Court decision were of a mindset that you were not going to use this court for a fishing expedition. That has probably changed.
The Patriot Act students don't go to the FISA court, do they?
Patriot Act did broaden the FISA provisions.
Patriot Act amended bunches of statutes, as Ann said. It did amend the FISA Act. It amended Title III of the Omnibus Crime Act of 1968. So it affects the traditional law enforcement side of the FBI's authority. And then it amends a whole bunch of privacy-related statutes, sometimes to provide safe harbors and immunities for employees to turn over information where it wasn't clear previously because of privacy provisions. If you thought you had uncovered something hot related to some potential terrorist attack, would you be subjecting yourself to liability? So a number of the provisions
But many of the
create
provisions
safe
wouldn't
harbors.
have anything to do with FISA, they see in other areas, other parts of the law.
That's correct. That's correct. And just to give you a couple of figures from this May testimony of Viet Dinh, who's one of the Justice Department officials most active in monitoring this counter-terrorist activity. DOJ was willing to report that the AG has approved 113 emergency authorizations under FISA. There's always been a provision that would allow the Attorney General to authorize an action that would require a court approval under FISA if it was an emergency. And then you have to go to the court then to get an order approving it. Used to be you had 24 hours when you could use the emergency authority. The statute expands that to 72. And John Ashcroft has used that emergency authority 113 times. And prior to Patriot Act, it had been used less than 50 times in the preceding 23 years. So it hasn't been overused in the past. I quite agree with that. The jury's entirely out on whether it's being overused now, but the activity has been ramped up a good deal. In large part, I think because the information now is much more useful because the wall between law enforcement and foreign intelligence activities has been lowered so that it now can be used to get other law enforcement agencies involved in amplifying the surveillance or expanding the information gathering net or tracking potential terrorists or suspected aiders and abettors in ways that it couldn't be before. So you both lowered the standards somewhat and made it much more useful in the enterprise of trying to prevent further domestic acts of terrorism. But I entirely agree that you have to be careful about the numbers. The fact that no FISA warrant has ever been turned down, I think, is just as much a sign of the care that's used in wanting to make sure there's a solid case for using it as there was for thinking the judges were rubber stamping it. I think it was probably more of the former than the latter, and I think that's probably still true. Yeah.
Well, I'm not a lawyer, I'm not a legal scholar. I work as network administrator for the Law Library of the University of Utah. And the thing that really makes me nervous about this is not necessarily how many times it has been used or how difficult it is to get it, but just this very wide potential for abuse of this because of the really relaxed requirements for getting this if you're willing to go through the process. We employ several Afghan nationals in our library, and one thing that concerns me is, if for instance, the FBI wants to investigate these people, there's no real requirement for them to hone in only on the data pertaining to this person's activities. They can come and ask for all of my records about anything. And what if in the course of that they discover another one of my patrons who is, has nothing to do with this initial investigation, but does appear to be doing something illegal? My understanding is they probably couldn't use that as direct evidence in a court proceeding, but they could use it to then go through the process to acquire that legitimately as sort of a fishing expedition. They could potentially go after anyone whose data they obtained legitimately through this act and use that. And in the context of a law library, where many of my patrons are there because they need information about the law, because they may be in legal trouble, or they may be preparing cases, and that makes me really nervous.
Well, I'm not here to calm your nerves any. A high-ranking official has to be, the Justice Department has to be prepared to certify to the court that the information thereafter relates to an investigation aimed at preventing acts of terrorism. The statute was created, for those of us old to remember this, because of abuses by J. Edgar Hoover of the Domestic Surveillance Authority of the FBI at a time when there was no FISA Act at all. He was abusing his power. No question about it. He was going after people that he had no business going after at all. We established this court procedure, albeit a secret court. This is a compromise. The president was maintaining in the 70s that he had foreign affairs, national security authority to do warrantless searches if it was in the interest of protecting the country from foreign invasion. And the Supreme Court decided a case that involved a purely domestic surveillance. And the court said the president's foreign affairs power doesn't extend to this warrantless search, but left open the door. So we're not deciding the issue of how about if it is a foreign power. And it's from that decision, the Keith decision, that you get the language that the Congress picked up on in 1978 in creating the FISA Court. Agent of a foreign power is language that Justice Powell used in the Keith decision. So what the Congress did in 78 was to say, we'll try to create a structure in which the president can go after foreign intelligence information under a lower standard than the criminal standard, because we're not aiming to prosecute people for crimes. We may, if it turns out there's a crime being permitted, but what we're aiming at is preventing foreign attack and foreign sabotage and foreign intelligence gathering on our soil. It's a counterintelligence measure. I think people were reasonably content with the view that that system was working pretty well from the point of civil liberties protections. The Justice Department had become increasingly frustrated by it in the 90s as it tried to deal with all these Al-Qaeda type groups, and discovered that it was dealing with a foreign affairs, what it viewed as a foreign affairs, foreign intelligence problem, and yet the equipment had become antiquated and it couldn't respond as nimbly as these disaggregated cells and loose connections of networks seem to require in terms of a response. So this is now, the Patriot Act's another response. It's a compromise that goes from where we were to something that's a little bit more permissive, and I think the jury's still out on whether it's going to be abused or not. I just don't think we know. I don't think we've got evidence that it has been abused to date. I mean, it's hard to tell, although it is interesting, and in part in response to, I think, the increasing concerns about it being expressed in the various ways Ann mentioned, that the Justice Department is becoming more forthcoming about what they're willing to disclose. Half a year ago, they told us they wouldn't tell us how many material witnesses they had detained. And in this May testimony, Viet Dinh said it was around 50. So, get more sunshine. My biggest criticism of the administration so far is we don't have enough sunshine on the Patriot Act activities. If they're using them as judiciously as they say, tell us more about it so we can come to that conclusion too. And unfortunately, this is an administration that's not big on disclosure, and that's not a problem limited to the Patriot Act area.
Quick follow-up. Are you aware of anything out there legally to protect the rights of the people who may be monitored who aren't specifically targeted by these sorts of things?
Well, the first check is the court order and whatever limitations are imposed on the warrant by the court, and then the second check can only be ex post. It's challenging misuses of the information afterwards. Everything in between is, as you know, under the gag order, and there's nothing proactive that somebody can do except those two things. Hope the court is scrutinizing, and if you have a legal beef about it, you'll have to challenge it after the fact.
We have a question. We may have, not quite on the Patriot Act, but I do want to let you know of a situation where the FBI went in at night to the library, not during the day, did not tell the director of the library, did not tell the university council, and went straight in to just the general information desk and proceeded to make their inquiries there first, and then never seized the actual workstations until the next day. They were investigating a kiddie porn thing that was taking place where the patron was coming in and using the library's workstation to contact people that way. So if you think that they're going to go to your university or to your head council first, I'll tell you they're not going to, based on the one example I've seen. And the other thing is, and it wasn't my library, if you think they're going to wait until at night when it's like the most vulnerable person is sitting at the information desk, yeah, they do. They go right after the weakest link.
I would take that one step further. We're talking about it in the context of users in the library, but in schools, there are computers everywhere. The kiddie porn could have easily been on a staff or faculty member's machine. And then is the FBI at that point coming to the IT administrators or the help desk personnel or whoever the lowest network administrator who could give them that information? Also, do they have to come to you? Because there's lots of technology involved that if they suspect a certain machine, potentially they might be able to get at it without coming to anybody. If they
Right.
suspect it, so if they've got this warrant, they can say, I suspect this IP address, I want to get at this. I'm not telling anybody, I'm just going to go after it and monitor it. Is that occurring? Or do you know?
Yeah. There's a somewhat higher threshold of what you have to testify to in your affidavit if you're not going to notify the target. I mean, if they're going to tell you, they can do it with a subpoena that the assistant U.S. attorney fills out in Raleigh. Hand it to you at the same time as they're taking away your computer. But yes, with a warrant, there are procedures to ask the court, and now I'm talking just the criminal process, not even the FISA process, to allow you to seize the material and not tell the person, if you've got a reason, if you have a reason for thinking that not telling him is going to aid the investigation or telling him is going to obstruct the investigation or something like that. But that is possible.
We can take one more question, then we should probably close.
I know that the Patriot Act changed some language in FISA where the Attorney General or official has to certify that it's a significant purpose of the surveillance has to be foreign intelligence, no longer the purpose. Now, the Department of Justice successively argued before the FISA Court of Appeal back in, I think, September, that means that the significant purpose for the surveillance can now be for law enforcement purposes. And the FISA Court of Appeal accepted that argument. I'm kind of curious to see how Congress will deal with that situation, because it seems like it undermines the purpose of the compromise between that was made in 1978 with passage of FISA, where it was not to be used as a law enforcement tool,
Yeah.
but now it can be. I know that very few cases that warrants that ever go to trial. I think that OITR said it's like 1% of the cases ever go to prosecute because they want to protect the sources. I'm very curious if they start using law enforcement purposes. It seems like that's once again going around the Fourth Amendment. And I'm kind of curious why the Supreme Court has not taken a case where they kind of settle with the matter. If they're going to start using this for law purposes.
Yeah. You've asked a whole series of very good and very complicated questions to answer. I mean, it's a long and disputed legal issue as to what that original compromise was, whether the interpretation the Justice Department gave it that required them to create the wall between law enforcement and foreign intelligence was ever required either by the Keith decision or by the initial statute, or whether that wasn't something that they had done more or less voluntarily, and so they could have undone it even without the Patriot Act having been enacted. That was one of the beefs they had with the lower court, the lower FISA court. It's not a very easy question to answer. You still have foreign intelligence information gathering as a significant purpose. And the Act historically always allowed information gathered under a foreign intelligence warrant to be used in a criminal proceeding if the Justice Department was prepared to defend it. There was never that kind of wall. And everything else is contested ground. It's very complicated. And people, I give you my answer and somebody else could give you just as an intelligent, quite different answer as to whether what has been done now was consistent or a breach of the original compromise. It's very uncertain.
On the other side is just going to say Zacharias himself and say we could have got the fourth pilot, except for the fact that we institutionally said we're not going to use this for law enforcement purposes.
Right.
So, there's two sides.
Thank you all for coming.